Hello, everyone. This is a new episode of the Global Judicial Integrity Network podcast series. My name is Melissa Evans, and we're here today with Judge Borkowski from Poland, who will speak with us about judicial independence and judicial immunities. First of all, thank you so much for agreeing to speak with us today. Could you please briefly tell us about your professional background?
As you said, I'm a judge. I'm a Polish judge. I used to be head of the Office of the National Council of Judiciary in Poland. Before that, I dealt with the judicial training, both in Poland and as a head of consultative board of HELP program in Council of Europe. I'm also Doctor of Law specializing in civil procedure and organization of justice issues. Now I work as an international legal expert in one of the Balkan countries, organizing the so-called governance bodies.
Thank you. So we'll be speaking about judicial immunities, but first I wanted to touch on the term judicial immunity. I think often judicial immunity is falsely conflated with diplomatic immunity. So could you please define judicial immunity and clarify how it differs from diplomatic immunity?
Well, it's not so easy. The question is easy, the answer usually is not so easy. It's not so easy to define the judicial immunity, but definitely it stems from the tradition of diplomatic immunity, which was the first immunity. Diplomatic immunity is a formal one, which means that diplomats are not liable criminally or under civil law or under tax law. Whereas with the judicial immunity, usually what we mean by this is that judges are not liable in civil cases regarding their judicial activities. Sometimes it also relates to criminal cases, but usually it's limited only to judicial activity of judges.
And could you tell us what are some ways that other branches of government often pressure the judiciary? And are there any patterns that you've seen repeating themselves worldwide in your research?
Oh yes, that's also a very good question, because the judiciary is quite often referred to as a third power in the state, but the power without the sword or gold, which means that the judges have usually no impact on the budget of the judiciary. And this is the easiest way for the administrative power to have an impact on the judiciary. So budget, not only budget of the judiciary as such, but sometimes it's also lowering the salaries of judges, of the court clerks. Another pattern, as you have put it, is lowering the pensioners' age. So if you lower the age at which judges become pensioners, you get rid of the certain parts of judiciary and, what is also important, the most experienced ones. Quite often the administrative power has an impact on nominating presidents of courts, or tries to have an impact on appointment and promotion procedure. What might be observed also lately, especially in the region, meaning Central Europe, is the media campaign against judges.
So someone mentioned earlier today that disciplinary proceedings had been used against judges, or as a way of maybe silencing judges. Could you comment on disciplinary proceedings being used against judges?
Yes, the disciplinary proceedings is an indispensable element of functioning of judiciary. It just the point is it has to be transparent. The problem arises when the disciplinary proceedings are being used against judges for their judicial activity. It is obvious that judges are disciplinarily liable for breaching the judicial ethics misconducts. The problem arises when the government, the administrative power, tries to use the disciplinary proceedings against judges for their judicial activities. For example, because of the judgments that they have given against the government, against another branches of power, or, for example, for asking the preliminary questions to Court of Justice in Luxembourg.
And how can the judiciaries deflect these kinds of pressures from other branches of government?
Well, this is very difficult. What judiciary definitely might do is to take care about high moral and ethical standards of judges. This is I should say, this is the main safeguard of judicial independence. Of course, it will only work properly if the procedure of appointment of judges and then of the promotion of judges is transparent, is merit-based on objective criteria. So this way, judges will win the trust in the society. And only this way, judges may defend themselves from such acts from the administrative power. Usually, judges have no right to go on strike. So our way of defending independence is, in fact, showing the society we are doing the right thing. As someone has put it some time ago, the real independence lies in the hearts of judges.
So how can judges best balance judicial immunities, judicial integrity and independence, and accountability of judges?
Definitely, judges cannot overuse the institution of immunity because otherwise this will not win the trust in society. In this case, what is particularly important is the issue of mutual trust. Trust between judiciary and the government, trust between judiciary and society. Only in this case, when the judiciary is open and transparent to society, only in case when there is a cooperation from the side of the government with the judiciary, the whole system will work properly and there will be balance between those issues you've mentioned.
So it's not only the judges who are balancing everything, but it's
definitely
the different
not.
Parts of society.
Yes, exactly. It has to work together.
How can member states show that the judiciary is independent from outside influences? How can they show that to the public or to other member states?
Well, definitely it has to be regulated in the law. This is quite obvious. What's more, taking into account the importance of the judicial immunity, it should be regulated on the constitutional level. What's more, it is also regulated, or it might be also regulated in international documents, so that the judges have the remedy not only on domestic level, but also in international level. But judicial independence, in fact, should be, as Judge Lafranc from the European Court of Human Rights has once said, for the judges it should be as natural as the air we breathe. So either a judge is independent or he or she is not a judge at all.
Thank you so much for speaking with us.
Thank you very much. It was a pleasure.
And for everyone listening, this has been another episode of the Global Judicial Integrity Network podcast series. Thank you so much.